Well, welcome, welcome, welcome. We are so super duper excited to have you all join us this evening. I am Erin Baptiste. I am the Special Education Director. And again, we want to welcome our families to this is our very second Parent Education Empowerment Resources and Support Session, which we lovingly refer to as peers. As a part of our transition series, our topic today is about guardianship. This peer session and the previous peer session and our subsequent peer sessions are a new initiative, and it's designed to educate our families, you all, promote engagement, and also increase parental access to meaningful community resources. Our DCSD parent educator and our staff have utilized parent feedback from participants such as yourself to plan and host these virtual sessions that will cover a multitude of topics and a range of speakers. Just to get ahead of things, next month on December 3rd, the topic is going to be about Medicaid waivers. So I think that's really important information, as is everything else. So please remember that and join us for the next session as well. Our department will also host, and we're happy to say this, a peers in-person event next semester, which will be our spring transition fair, which will be March 22nd at Redan High School, and more information about that is forthcoming. Please note, and I'm sure you did see it in our opening video, that we do have interpretation available, language and sign language interpretation available for you. If you can please click the ellipses with more, and you can get into a breakout session if you do require that accommodation. We have that available. Without further ado, I do want to introduce our DeKalb County School District staff that worked really hard planning this event and previous and subsequent events. And as our parent liaison, Ms. Lisa Lake. We also have one of our senior coordinators, two senior coordinators that are instrumental in supporting this series. That's Ms. Rolanda Johnson and Dr. Danielle Howard Thomas. We also have a host of transition liaisons that do put in work and support our transition for our students, and that's Ms. Pamela Gordon, Ms. Latanya Wilson, Mr. Rodney Allen, and Mr. John Norwood. So at this time, I'm going to go ahead and turn it over to Ms. Lisa Lake so that she can give you all some, housekeeping as we move forward through the session. Thank you and have a good evening.
Welcome again, everyone. I'm so excited to have you guys here today. Again, I'm Lisa Lake, the Parent Transition Liaison, and just for a couple of announcements with the way the session is going to go tonight, we do ask everyone to stay on mute, so you will not be able to unmute yourself. If you do have a question, you will be able to put it in the chat. And we are going to have a question and answer period around 7 p.m. We'll open up that chat, and we'll have some of our coordinators start to go through the chat and answer your questions, present the questions to our speaker and allow him to answer the questions at around 7 p.m. And without any further ado, I'd also would like to introduce our speaker for tonight. Attorney DJ Jairam is from Jairam and Associates. He is a special needs attorney. He is also a judge, I believe, and I'm sure he's going to tell you a little bit more about his experience and maybe even some things about his practice. But we are incredibly excited to have him here tonight to talk about guardianship and conservatorship and just all different types of legal options for your child with a disability. So without any further ado, I'm going to turn it over to Dr. Jairam.
All right. Good evening, everyone. I appreciate everyone being here to talk about this topic. This is an incredibly important topic and sometimes even maybe a little controversial. And so I want to make sure we take the controversy out of it. I want to give you some just good, understandable information. Glad to answer your questions at the end. Lisa, can you see my screen? Okay. All right. So again, my name's DJ Jairam. I am a special needs attorney. What we specialize in at my firm is we do help with guardianships and powers of attorney, as well as special needs estate planning. Today's topic is guardianship and its alternatives. I know the opening screen just said guardianship, but I do want to talk about guardianship and the alternative so you can pick whatever works best for your family. And so there are a couple alternatives that I will talk about. Just to be clear, I am not advocating for one alternative over another. I'm just going to give you the information as I see it. My opinion will be mixed into that information as well. And you can take that with a grain of salt, but obviously do what is best for you and your family. All right. So I do have to say this as a disclaimer. I'm not giving any specific legal advice to anyone. Like I said, I'll try and give you some good, understandable information. But if you need help with your particular situation, feel free to reach out to me or another qualified attorney. And Lisa reminded me to take a breath to allow for the translation. So if I do pause from time to time, that's going to be why I'm pausing. But again, this is not particular legal information to your situation, just general legal information. Just a little bit about my experience. I've been practicing for 27 years now. I did start off with the Georgia Department of Community Health. I ended my time there as the Deputy Director for Legal Services. If you're familiar with DCH, it runs the Medicaid, the Katie Beckett program, the now comp waiver, types of services that you may have heard of. I do work as a judge in Gwinnett County. I work as a magistrate judge about 35 hours a week doing that. And some of the examples I will give to you as we work through the presentation are going to be from my experience as a judge and as an attorney. I did go to law school here locally, so I was trained here in Georgia at Emory University. But this is really why I do what I do. This is my son, Kai. Kai's 15 years old. He is on the autism spectrum. He also has a condition called Williams syndrome. Those things translate into a pretty significant intellectual disability. And so everything we're going to talk about today, the guardianship, the alternatives, those are things that my wife and I are considering for Kai as he approaches the age of 18. And so hopefully that adds an additional layer beyond the attorney work and the judicial work I do. But I also approach this very much as a parent. And I do not by any means, minimize any parents' feelings on this topic. Like I said, it's not always the easiest topic to address. All right, so what are we going to talk about today? Here are the goals for today. We're going to talk about what is a guardian. There's some misconceptions out there. I just want to make it clear what a guardian is, what it's not. We'll talk about a little bit about conservatorship as well, because that is one of the concepts that gets mixed up with guardianship from time to time. I'll talk about the legal standard for getting guardianship. If it is something you're considering for your loved one, what do you have to show? What do you have to prove to get guardianship issued? I'll offer a couple pieces of information of practical decision-making tips. The legal standard is very important, but not always useful for decision-making. I will give you some practical decisions or questions that you can ask yourself in reaching a good decision for your family. I'll talk about choosing a good guardian. It's not easy. In typical situations, it might be a little easier than in a special needs situation. I'll explain why when we get there. I will also talk about the general understanding or give you a general understanding of the guardianship process. What do you have to do if you choose to go down that road? What will it look like? What do you have to show? What's the evidence you'll have to present? I'll offer some advice on all of that. And then ultimately, I'll wrap up with the alternatives to guardianship, okay? Now, I'll tell you this up front. There are a lot more slides here tonight about guardianship and fewer about the alternatives. That is not indicative of how I feel about those alternatives, okay? You do what's best for you and your family. Don't let anyone, myself, or anyone else guilt you into one choice over another. There is no one-size-fits-all answer to this question. So just because there are fewer slides, that does not mean I think less of those alternatives. Okay. Some questions were submitted ahead of time, so I wanted to make sure we had a slide to address that. I will make sure at the end of my presentation, I will return to this slide And if I have not answered these questions, I will absolutely make sure I do that. And we will have the Q&A period as well. All right, so guardianship. Well, what is it? So guardianship is final decision-making authority that one individual will have over someone else. Now, when our kids are under the age of 18, okay, the natural parents are the guardians. Now, so if the natural parents are not around, it could be somebody else appointed by a court. But really, since as this is a transition series, well, I know what most of you are here to hear about is what happens when our kids turn 18. Well, when our kids turn 18 in the state of Georgia, they become a legal adult with all the rights and responsibilities of an 18-year-old adult in Georgia. Unless you go through that guardianship process. And what that process is legal rights, certain legal rights are removed from that 18-year-old, which is called the ward, are removed from the ward and vested back with the guardian. Something important to understand is no matter how challenged your child may be, or how obvious it would be to you that they would need a guardian and need help, and maybe not be able to make certain kinds of decisions, the parent does not automatically become the guardian. When the child turns 18, if the parent wants to retain guardianship, they have to go through the guardianship process with your county probate court to have those rights removed from the child and revested with the guardian. It is not automatic. And I'll talk a little bit later about when you should start that process. Now, there's a big difference between a guardianship and a conservator. I like to think of that, they're both sides of the same coin. So with guardianship, that is legal decision-making authority over an individual. Conservatorship is legal decision-making authority over that person's stuff. The stuff they own, the stuff they control, money, accounts, things of that nature. Just because you have guardianship does not mean you have to have conservatorship, and vice versa. And so while they're definitely related, you don't have to get both. I will tell you, and it's not the focus of today's presentation, but for many of us, as our kids turn 18, one of the things we're going to be thinking about is getting SSI and Medicaid for our adult special needs kids. Well, anything in a conservatorship, SSI considers the child's asset, and they will consider that in determining whether they qualify for benefits. So be super, super careful if you do get conservatorship while you're going through the process. If you put any assets into that conservatorship, that could affect eligibility for benefits. You may want to think about a special needs trust instead, but that's a presentation for a different day. But so for our purposes today, guardianship is decision-making authority over somebody else. So who's going to need a guardian? Like I said, all minors, anyone under the age of 18 needs a legal guardian. And so you may have seen this in a will. If you have a will, you will list some guardians. Hey, if anything happens to mom or dad or whoever is taking care of that minor child, if anything happens to me, these are the people I want to succeed me as guardian. So certainly anyone under the age of 18. Over the age of 18, it is what are considered incapacitated adults. Now, what does that mean? I'm going to get into that legal standard in just a minute, on determining whether that adult lacks capacity to the level that guardianship can be granted. The first question I always get is, what about power of attorney? I always hear about power of attorney. That is a major alternative, and I am absolutely going to talk about that in a slide a little bit later. When should you start the process of guardianship as your child starts approaching the age of 18? In most counties, almost all counties in Georgia, your local probate court will allow you to file for guardianship when the child turns 17 and a half. That gives time for the petition to be filed, to work through the process, to get in front of that judge, and get those guardianship papers issued very close to the time that your child is actually turning 18. Because of that, there's no gap in the decision-making authority for the parent or the caregiver in being able to help the child. You go from the natural guardian of a minor to the appointed guardian of an adult with no gaps. Okay, so what I would always suggest is maybe when your child is 17, you want to start having these discussions. You know, is guardianship right? Is an alternative right? Whatever is right, you start gathering that information so that when your child does turn 18 about a year later, everything's in place. It'll be a smooth, relatively stress-free transition, and nothing's going to interrupt your ability to help that child. So 17 is when you want to start thinking about it. 17 and a half is when you really want to get the ball rolling on it. All right. How important is it to have guardians in your will? This is something that I think it bears commenting on, because it applies in two ways. One, if you are the parent of a minor child and you're naming guardians in a will, or you are the guardian of an adult child and you're naming your successor guardians in your will. So the scenario is, on the way home from an outing, Homer and Marge are in an accident and both pass away. If they do not have wills and have not selected guardians because they don't have wills, don't have guardians named in a will, what happens? Who becomes that child's guardian? Well, on the day of the accident, who takes the kids? Well, we really don't know who takes the kids. An emergency guardian? Is it DFACS? It depends on your county. What happens in the weeks that follow and what happens in the long run? Well, I will tell you, there's a statute out there that has a priority of guardianship, and the court follows that priority. Now, they're not 100% bound to it, but that is what they follow. And number one on that list is, who did the natural guardians, mom and dad or mom or dad, name in the will as to be the successor to them? That's number one. If that does not exist, they go to number two. Grandparents, aunts or uncles. Well, what if there's more than one grandparent? What if there's more than one aunt or uncle? I will tell you, and this is just from my time on the bench, that you do not want that decision to go to a judge. Because if you have to remember, people are grieving in this situation. And so you might have multiple aunts or uncles or grandparents stepping up and saying, I will take care of this child. And as beautiful as that is, that may not be the person you would want watching out for your child. And so I urge you that if you don't have even just a basic will, to get one in place and take this opportunity to vote for the person who will step into your shoes if you can't be there. This is your opportunity to do that. Okay, don't pass it by. Do not ever leave it up to the judge to make that call. Because I will tell you from personal experience, People can get on that stand and they can fake being sane for 15 minutes. Okay. And, Murphy's Law is that's who's the judge is going to pick. You know the players in your life and your child's life, no one will make a better decision than you. So please take that opportunity. All right. Talk about the legal standard for guardianship. This is the legal standard for adult guardianship up on the screen. I'm just going to read it verbatim. The court may appoint a guardian for an adult only if the court finds that adult lacks sufficient capacity to make or communicate significant responsible decisions concerning his or her health or safety. Clear as mud. To me, as a parent, I'm like, I don't know what that means. I don't know a single 18-year-old who can really do that well anyway, special needs or not. So that's clearly not the standard. Okay. So I'm going to give you some practical decision-making tips here on the next slide. But one of the number one questions I get is guardianship seems so permanent, that rights are being taken away from my child and they're given to me. And it feels very wrong as a parent that we fought our entire lives for our kids' rights, whether it's through, and maybe it's not fighting, but an IEP process or a Medicaid process or benefits or just ignorance in the community. And it feels very wrong to be the one now turning around and taking those rights from them. And I completely understand that. Please understand that guardianship can be reversed. It does not have to be permanent. Now, once it's in place, it's got to stay in place for a couple of years. But then if your child just needs time to mature, time to learn better decision-making skills, just more life experience. Okay, so it's not that they will never get there. They're just not there quite yet. You can always go back to that probate court. You do have to go through the process in reverse. It's not enough just to say, hey, I want my child to have their rights back. You're going to have to go in front of that judge and say, I want my child to have their rights back because they no longer meet this legal standard. And here's why. Because to get guardianship granted, you had to explain to that judge and present some evidence on why your child meets the standard on the screen. Well, now you've got to go back, and if you want those rights restored, you have to explain to that judge why that is no longer the case and present some evidence. So it is a serious thing. It is a legal process, but it can be reversed upon presentation of sufficient evidence. All right, let me give you the practical standards for guardianship. And I will tell you, maybe of any of the slides I have here, this one may be, if there's controversy in this presentation, this may be the most controversial. I have heard certain advocates disagree with me on this. All I can tell you is, I've been practicing for 27 years, 10 of that as a judge. And so I'm basing this on my experience. I don't know what those advocates' experiences may be, and I'm not discounting it. So take this with a grain of salt. But for me as a parent, this is what I would want to know. And like, hey, is guardianship right for my child or not? So one of the powers that is taken away from the child and revested with a guardian is the right to enter into a contract. Now, to me as a parent, one of my biggest fears, and just talking to lots of clients and hearing their hopes and fears, is that my child's going to get taken advantage of. That people are going to get them to sign things or give them things or take advantage of what is many of our kids just have the sweetest dispositions and nature, and they can be taken advantage of. And so the ability to sign a contract is taken away from them and given back to the parent. So let me give you an example. This is an older example and not one from my practice, but from one of my mentors. And this was back when credit card companies used to call you right around dinner time and try and sell you, credit, sign up for credit cards. And so there was a higher functioning young man on the autism spectrum, and it was verbal. And one of these calls came in during dinner time. He answered the phone, and it was, if you're old enough to remember this, the spiel was something along the lines of, look, no payments for 12 months, 0% interest, it's like free money until 12 months from now. And so there was no guardianship in place in this situation. And that adult child with autism said, yes, I would like a card. The card was mailed to him. And amongst his chores was to get the mail every day. And so he got the mail, got the card, and he was still in high school, and he took it to school the next day. Well, what do you think happened? Well, one of the things we see is the higher functioning our kids, if they have additional needs, the higher functioning they are, the more they realize what they may not have in their lives. And talking to the kids themselves, which I do a lot, it's almost always friends or boyfriends or girlfriends, significant other relationships. Well, he went into school, he was waving the credit card around, and all of a sudden he had friends that he did not have the day before. And he ran that card up to the limit on the first day he had it, because he was buying things for these people who, in my opinion, were taking advantage. So the bill comes in. Mom and dad do see the bill. After the shock wears off, they call the credit card company and say, look, he's on the autism spectrum. We have an IEP. We have a psychological evaluation. We have diagnoses we can send you. What can we do about this? What do you think the credit card company said? They said, oh, we're so sorry for all of that. When can we expect our payment? Because that child at 18 had the ability to enter into a contract, and that's exactly what happened. Now, you can get out of it, right? I mean, you would have to go to court. You'd have to argue in front of a judge that that child lacked capacity to understand what was in the contract, and the contract is therefore invalid. You can do that. You would have that opportunity if you chose to. Was the credit card company going to fight that? You better believe they're going to fight it. Are they going to have an attorney? Yep. Do you think that you hiring an attorney to fight that is going to cost you pretty much as just paying the bill? It sure will. And I will tell you this again from my judicial experience, that judges are very reluctant to let people out of a contract just because they say they didn't read it or understand it. Because everybody says that. I bought a house without reading the contract. We all do. Okay. So that's not a reason to get out of the contract. Now, if guardianship was in place, that right has been removed from that 18-year-old. That contract, the argument would be that contract never existed. It's like a 5-year-old signing that contract. I've heard advocates say, well, that's not entirely true. In my experience, that is true. And so even if you did go to court, even if that credit card company did sue for that money, well, guess what? You can tell that judge, hey, judge, before any of this happened, a court of competent jurisdiction, that your county probate court, already adjudicated the fact that my child cannot make, going back to the standard, does not have capacity to make or communicate significant responsible decisions. That's going to mean something to a judge, because it's not an excuse to get out of a contract. It was already done. Okay. So again, take my opinion with a grain of salt, but I think what I'm telling you makes some logical sense as well. Um, the other one that I like to talk about is not real popular. I don't hear a lot of attorneys talk about this, but I'm going to talk about it anyway. And that's interaction with law enforcement. The 32 to 35 hours a week I spend on the bench, the vast majority of it is on felony criminal matters in Gwinnett County. And so I do have the opportunity to speak to law enforcement quite a bit and to the prosecutors and solicitors' offices that prosecute crimes. And I ask them, they know I give these presentations, so I always, pick their brain. Hey, how would you guys approach these situations? And the scenario I give them, and this is one that I could see my son in, which is part of the reason I give them the scenario, is if my son's at the mall and he likes the girls and he's going to be talking to the girl and she's being nice to him, but now it's time to leave and she turns to leave and he grabs her arm. I mean, he grabs it a little too hard. And the clerk of that store calls the off-duty officer who's moonlighting there. I asked the officers, would you make that arrest? And what officers tell me, not all of them, but the majority, especially the young officers, we all know, we all see it on YouTube or maybe TikTok. I don't watch it, but people watch body cam footage for entertainment these days. That is not lost on the officers, that every move they make is being examined. So if there is probable cause for them to make an arrest for battery or simple battery, they tend to do it. Because if they exercise discretion in the field, and then my son goes off and hurts somebody because they didn't make that arrest, guess who's on the evening news? So the officer ends up, generally, they'll make an arrest, they'll bring the child in. And again, I mean adult child. Bring the child in, they'll come in front of the magistrate, which is what I do, and say, look, judge, it's a special needs kid. I don't really care if you issue this warrant or not. I just had to make the arrest. Well, at that point, guess what? I don't have the discretion to say no either. At that point, my job is to say, did this officer actually have probable cause to issue the warrant? Not should he have done it. That's not the time for it. So I say, look, you had probable cause. I'm issuing the warrant. In that scenario, then ask the prosecutors, what would you do with this case? And I asked the officer and the prosecutors, would it matter if there was guardianship or an alternative in place in how you approach this situation? Every single officer and prosecutor, and again, I am not advocating for guardianship, but every single one said guardianship would make a difference. And again, it's that phrase that I said before, because a court of competent jurisdiction has adjudicated the fact my child cannot make reasoned decisions. Well, if they can't make reasoned decisions, how can they form criminal intent? So the officer's eyes glaze over, the prosecutor's eyes glaze over, and they go, you know what? If no one was hurt and that young lady's not the one who called the police, it was a clerk, they'll kick it, go home, don't do it again. So guardianship does provide what I call actual legal protections. Okay. I'm going to use this example again when we talk about the alternatives and see how is it going to play out with those alternatives. But, we got to be, I think not talking about this piece with interaction with law enforcement in today's climate is a mistake. I think it is something to consider when making these decisions. All right. What rights are actually removed? What are the list of rights that are removed from an individual if you go through the guardianship process? Number one is the right to get married. You know, it's technically entering into a contract. And so that is a right that is removed. Number two, like I said, the right to make contracts or modify contracts. Number three is the right to make your own medical decisions, right? That right is given back to the guardian to help determine medical decision-making. Number four, where do you live? This is one I see every now and then. I have a special needs individual that has taken off to a different state, or it doesn't even have to be a different state. Well, they're 18. The parents have come in and said, look, they're a special needs individual. You know, the IQ is this, the level of functioning is this. And say, okay, they're 18. Do you have do you have guardianship in place? No. I can't do anything about that. That is an adult who's made the decision to leave. Can't do anything about it. Now, if guardianship's in place, I can do something about it, because then you've got the argument that this is essentially someone like a minor, and you can engage law enforcement in assisting in getting that child back. The right to create trusts, the right to bring a lawsuit is lost. The ability to drive is lost. Question I get all the time is voting. Is voting removed? Voting is not in the statute as a right that is automatically removed. Many times it is. But something to remember is the statute always says that guardianship should only be put in place in the least restrictive way possible. So you can always approach the court and try to make the argument, I want them to be able to keep some of these rights. I want them to be able to drive, for example. I understand maybe not the other ones, but they can drive, and I want them to do that. You can always ask the court for that. Now, realistically, in my experience, you're going to have to present evidence. You can't just ask for it. Hey, here's the driving instructor. We're calling them as a witness. Here's the tests he's taken. Here's his score on the road test. This is how long he's been taking lessons from a professional company. Right? You're going to have to convince that judge, yes, I'm saying he may lack or she may lack capacity in certain areas, but not in others. You're going to have to say why. But that's what I call limited guardianship, where only certain rights are taken, while other rights are left with the individual. We have done this before, but like I said, it does take, normally take some presenting of evidence. Whenever I talk about what a probate court judge may or may not do, please understand I'm generalizing. Depends on the judge, depends on your county, depends on the day of the week, and maybe what they had for breakfast. So, you know, just take that all with a grain of salt. All right. Choosing a guardian. Now, what I'm really talking about here is choosing a successor guardian for a minor or an adult. You got to ask yourself some questions, okay? Because what I see a lot when I'm doing even just a basic will for someone is they'll say, I want, you know, my sister to be my child's guardian, or my brother, or my aunt, or uncle, or grandparent, because they love that child the best. And that is absolutely the most important criteria. Do not get me wrong. But to make the best decision possible, I encourage you to ask more questions. So among those questions, how old are these successor guardians? I mentioned grandparent. I'm an older parent. I had kids later in life. I don't have the energy to raise my kids. There is no way my parents have the energy to raise my kids. Okay, you got to ask, right? Just kind of put them in your shoes and say, can they do what I do? Not, can they watch them for a weekend? That's not the job anymore. What is the health of that potential guardian? Do they have their own issues, right? Are they helping maybe take care of a spouse who has health issues, or elderly parents of their own that they're taking care of? You know, we're called the sandwich generation. where we take care of, kids and we're taking care of our aging parents. Okay, that's a lot on one plate. So do they have the time? Do they have a relationship with that minor or adult child? I get this one a lot. I'm appointing my sister in California as the guardian. I'll say, great. How often do they get to see your child? Every holiday in December. They come and visit, or we go visit out there. So, okay. When is this person going to step into your shoes? Well, there's only one way it happens: suddenly or naturally. If it happens suddenly, you have to think about this in practical effect. One day your child is here, the next day they're there in California. Or maybe the person from California is coming here. But either way, if they're only seeing that person once a year, is that going to be the best choice? It might be. Again, no right or wrong answer, but the more questions we ask, the better decision we're going to make. Like I said, where do they live? Location matters. You guys are obviously in a good school district that cares about their kids, and especially their special needs kids. And if you have a good teacher, if you have a good IEP, if your child has friends in the community, you have good therapists, you have a good primary physician or a dentist. Well, if you can keep your child in that situation, would that be what's best for them? Maybe. Or it might be going to live with the aunt in California. I don't know. But you got to ask the question. And if you ask the question and they go to California, you're going to have to start over with that stuff. Okay. So just practical, obvious decision-making points that the more we dig in, it's like, look, if we choose, Sally in California, it's going to be a new school, going to be new friends, new doctor, new therapist. We have to think about that. This is one I always like to make sure I point out, and that is stress. Anyone who is a parent knows it's stressful. Anyone who is a special needs parent knows it's incredibly stressful. And so these people you're choosing, how do they handle stress? Right? Because it is not easy to step into a special need parent's shoes unexpectedly, because you're not getting that child on their best day. You're getting that child in crisis. And so whatever stress you've seen that parent go through, it's probably going to be more significant. So just give it some thought, because there are two thoughts to guardians, right? There's immediate in an emergency if something happens unexpectedly, and then there's long-term. If I pass of natural causes and I've got time to choose some younger folks to step in, that's a different situation. And hopefully that's the situation we're going to find ourselves in, but we may not. And I do not believe in taking chances. So the more questions we ask, the better decisions we're going to make. Couple tips on how to do it. Just sit down with a piece of paper, list all the people who are in your orbit who might potentially fill that role of successor guardian, and list the strengths and weaknesses. Hey, they're not close, but they're financially secure, emotionally secure, and patient, and they live in an area that there's lots of services. I mean, really talk it through. You got to accept the fact you will not find your clone. I mean, we see that all the time. I feel it too. It's like, nobody's going to do this for my child the way we do it. And that's true. That is true. But we have to make a decision. We have to make a decision. A way that makes decision-making easier is if you look at this and say, look, if anything happens to my wife and I in the next, I'm talking about my family, but happens to my wife and I or the caretakers in your family in the next 3 to 5 years, who's going to step in? Because if you start thinking, well, there's 3 to 5, but What about 15, 20, 35, 40 years down the road? That's when we get that deer in headlights and we end up going, you know what, this is too stressful to think about. I'm going to watch some Netflix. And so, you know, if you kind of shrink that focus 3 to 5 years, it'll help you make initial decisions. So if the worst happens, you've made a choice. You can always change your mind. It's not hard, it's not expensive, but obviously if you have not made a choice and something happens, you know, that opportunity is gone. Okay. How do you talk to successor guardians about filling in that role? Be honest about your life. Okay. Do not tell them about your best day because that's not realistic. Do not tell them about your worst day because nobody will ever sign up to be your child's guardian. Tell them about your average day because you're hiring for a job. Okay. You don't ever want them to step into those shoes and go, wow, this is not what I thought it was going to be. And then they want to quit. That is the worst thing for your child, and that is a bad thing for them as well. So sit down, tell them about your life, what your average day looks like. Don't worry about hurting people's feelings. I get this one a lot. Well, I want to choose my friend because they spend the most time with my child. They'd be the best in all those little micro questions. But it would crush my sister or my brother. Honestly, my reaction to that is I'm sorry, but so what? I mean, you kind of have to do what's best for your child. And you know what? I bet your sister or brother really will understand. I know you're concerned about it. They're going to understand. And they're still going to be there. They can still help. This doesn't mean they can't be in the child's life. It just means they don't have that legal title. Give them time to think about it. Right? Because I will tell you, everybody feels like a jerk if someone says, will you be a guardian? And you're like, yeah, no. Nobody does that. Sometimes they're guilted into saying yes. So I always suggest, look, I'm going to talk to you about this. I don't want you to answer me today. I want you to go home, speak to your spouse, your kids, your significant other, because, you know, it's going to be a family thing. And get back to me, you know, next week. You know, we'll have some coffee and you can tell me, you know, what you're thinking, and I'll answer any questions you've got. And I always suggest you tell them when you're thinking about it, if you say no, I will completely understand and it will not affect our relationship. Now, I'll be honest with you. I'm completely lying when I say that part, completely lying about it, because it's absolutely going to affect our relationship. Because I will be hurt. I'll get over it, but for at least a little bit, I'm going to be hurt. But I do want them to say no. I do. Because if they can't do the job, I don't want to hire them for it. Okay. Let's see. A couple things to do to prepare your successor guardians for success. Let them know what makes your child tick. You know, what are their allergies? What are their favorite foods? Are they on any meds? What do they need to be aware of? Do they need to monitor internet access? Are they, you know, do they tend to wander at night? So you got to make sure the doors are locked. I mean, whatever it is, okay, you have to educate them because they don't know what you know. Nobody knows what you know. So you got to write it down. It's called a letter of intent. We call it a letter to the guardian. One very easy way to do this is, and it's completely free, start an email address in the name of your child that only you control. And if you have a bedtime process, bath time process, ways that child communicates, sensory triggers, soothing techniques, whatever it is, take your phone out the next time you're doing those things and just take a short video and email it to that email address with something obvious like bedtime process, bath time process, feeding, taking meds. changing a G-tube. And now your guardian has a video log of how to care for your child. You're going to take that email address and password, you're going to put it with your will, your estate planning binder, and now they're as well trained as they possibly can be. Okay. It's free, it's easy, it's just about training ourselves. I know I will put money, at least 90% of us have our phones within arm's reach, because that's just the society we are. Okay, we've got our phones all the time. Just got to train ourselves. I know I'm getting to that Q&A section, so I'm going to move on a little bit. The guardianship process, if you do choose to do guardianship, it is a legal process. You do file a petition with your local probate court for adult guardianship. Once you file it, you can have certain fees waived. I know that was one of the questions. So there is something called a pauperis form, Pauperis. You fill out a form, and based on your financial situation, the courts can waive certain fees. So while there normally is a fee, you file with that petition, generally somewhere between $500 or $600. Some of that can be waived, or all of it can be waived if you meet the financial. So they may not tell you about that. So if you go to the clerk's office and say, look, do you have that pauperis form? It doesn't hurt to fill it out. The worst thing they'll say is no. Okay. Once that petition is filed, it gets reviewed. An attorney is appointed for your child. Their job is to represent your child. Okay. Your child will also be examined or interviewed by a psychologist, a psychiatrist, or a social worker. That person will fill out a standard court form, basically saying whether they feel your child meets the legal standard for guardianship. Ultimately, at the end of the guardianship process, you do end up in court, or I should say in front of a judge. In some counties, it's more informal. It could be in a conference room. In other counties, it's actually in the probate courtroom. So the formality depends on where you live. At that hearing, the parent who's filed the petition, or parents who filed the petition, will have to present evidence on why the child meets the legal standard for guardianship to be awarded. Most judges will rule directly from the bench, yes, you've met the standard or not. Do you need an attorney to get guardianship? No, you don't. Provided that it is not a contested case, meaning there's not maybe an ex-spouse on the other side saying this child does not need guardianship, provided that the psychologist or social worker did not check off the box saying this child does not need guardianship. Or occasionally when you get really high functioning kids and you're like, wow, this kid's really smart, has all these capabilities, but mom or dad is seeking guardianship, you may want to consider an attorney in that situation. But for the vast majority of situations, my son's included, where it's going to be obvious to anybody this child needs a guardian, then, and it's just about jumping through the legal hoops. There are training videos out there. I saw you had parent to parent doing your next next presentation. They've got a library of videos. There are other support groups out there. You can figure it out on your own. It's not brain surgery. If you need some assistance, there are firms, my firm included, that will offer trainings to families one-on-one on how to get guardianship. It's a lot less expensive to do it that way than to hire an attorney to take you through the entire process. So there are options. You don't need an attorney. You can figure it out. You can train off those videos that are free out there. You can hire for some assistance in training, or you can hire an attorney to assist you. All right. Let me get to the alternatives so I leave plenty of time for questions. So the biggest alternative to guardianship is power of attorney. Under power of attorney, that would be documents that the special needs adult child will sign authorizing whoever they choose, could be mom and dad, could be someone else, but whoever they choose as their agent, saying, look, they keep all of their rights. That special needs individual has all of their rights. Saying, but mom or dad or agent, you can go out and exercise those rights on my behalf. You can make that doctor's appointment. You can open that bank account. You can talk to my school system. You can do anything I can do. If I give you authority to do it, you can do it too. Okay. It's less restrictive than guardianship because no rights are taken from the child. By the same token, remember that example I gave you before about the credit card, law enforcement? Well, with power of attorney, that child has all of their rights. They can still enter into the contract. Okay? With that law enforcement example, well, a court has not adjudicated the fact this child cannot make any decisions. Actually, the opposite is true. Because if you have your child sign power of attorney, you're basically saying to whoever is asking, that child has capacity to understand what they just signed. The basics of it. I'm not talking about the legalese, but they understand they have rights. They're letting me exercise them. Okay. Understand that the agent can be overruled by the special needs child. So the agent makes an appointment to get the wisdom teeth removed. The child walks in, and this is an actual example. Child walks into that oral surgeon's office, hears a drill in the background, says, nope, not going to do it, walks out the door. Well, that's not happening. That surgery is not happening. That principal, the child, can always overrule their agent. Power of attorney can be revoked. I just had one of those happen the other day. I had drafted powers of attorney for an adult special needs child. The child did not like something mom and dad were doing. The child removed them as his agents and put someone else in place. They can do that. If you do decide to go down this road, it's just having certain powers of attorney done. You have some attorneys will do one document, durable general power of attorney. We like doing separate ones, one for finances, one for healthcare, one for education, and a HIPAA waiver as well. But these three, the reason we like this, if you're giving it to a school system, they don't need to know finances and healthcare. So you can give them the one that says education. If you're going to the doctor, does the doctor need to know about education? No, they care about healthcare. So to me, it just helps to have more specific ones in place. But if you do power of attorney, the child executes on their 18th birthday or after. I always suggest notarization on everything, even if it's not required. And the agent should carry a copy of that or take pictures of each page on their phone, and they can exercise that authority on behalf of the principal. So this is the major alternative to guardianship. Another alternative, and I actually did get an email from somebody about this, or a Facebook message about talking about this issue, and that is supported decision-making. Supported decision-making is important. It is about teaching individuals how to make good decisions. It's about putting support structures around them, whether it's people or a group of people, to help them understand the pros and cons of decision-making and hopefully leading them towards what that individual determines to be a good decision. It's a wonderful concept. Right now, since there isn't legislation in Georgia reflecting this, it's just a concept. And in my opinion, and I'm probably going to get emails about this afterwards, but in my opinion, supported decision-making can fit within guardianship, and it can fit within power of attorney. Because just because I have guardianship over my son does not mean I stop parenting him. I will still explain to him, this is how you make a good decision. This is how you do these things. And I can allow him to make those decisions. But if he's going to make one that's going to hurt him, and I mean really hurt, not just like hurt his feelings, I can stop it with guardianship. Under power of attorney, same thing, right? You can help guide them. And in power of attorney, they absolutely still have the authority to overrule you. So supporting decision-making fits very nicely under power of attorney, certainly. So while people say this is an option, I really think it's a methodology right now in Georgia that can be used within power of attorney, absolutely, and to an extent within guardianship. It's about how to make good decisions. I guess, what if we don't have anybody to appoint as a successor guardian? I hear that a lot. The sad reality is you have to find somebody. You have to. Any decision you make is going to be better than a decision that a judge makes on that issue. And if you don't appoint someone and nobody steps up, then you're talking about a county guardian or a public guardian, which could be DFACS. It could be an attorney from a list from the probate court. And just having worked with those types of guardians in the past, anybody who knows you and your child is going to do a better job than people who don't know you or your child. So part of our charge as parents is going to be, identifying people who might be willing to serve. I do have a lot of free resources out there on our website and our YouTube page. Just little short videos, a couple of minutes long, about guardianship, about power of attorney, supported decision-making. So if you need a refresher on anything I've said, feel free to access that. It's all free. And if you have any questions, my email's here. Hopefully you can see that at the bottom of the screen. That's my email, dj@jlaw.com. Feel free to email me. I'm always glad to answer questions. As long as it's not going to take hours upon hours, but I'm glad to answer questions if you just need clarification on anything I've said. So with that, I am glad to answer any questions.
Well, we do have quite a few questions. Rolanda, are you ready?
I said I was going to go back to that previous slide. So
Lisa, unfortunately, I'm not able to see the webinar questions in the chat.
Okay, let me check and see if I can find them. And they might be
Okay.
Well, while you're doing that, let me go ahead and answer the questions that were sent in early. Does guardianship cover health? Yes. As easy an answer as I can give you. Yes, it does. Can there be multiple guardians in case something happens to one? Yes, you can have co-guardians. But when you have co-guardians, those are two people serving at the same time. So they're kind of a guardianship team. And so they have to agree on decision-making, which is fine. Generally, what happens if say it's parents, say it's a husband and a wife or guardians over their child, if one of them passes away, we do suggest you get those guardianship letters reissued just in the name of the one surviving parent. You don't have to go through the entire process. It's usually just filing a petition for issuance of new guardianship letters and maybe a death certificate of the guardian who's passed, but you probably will have to get new letters issued. Does guardianship cover a lifetime or only for a period of time? It's in place until revoked. How much does it cost for a parent to get guardianship? Like I said, your court costs are between, I don't know exactly what it is in DeKalb, but I think it's between $500 or $600. Are there financial assistance options? There is, like I said, the pauperous form that can relieve some of that burden. And don't hold me to this, there's a benefit out there called Family Support Services dollars that I think may be able to be used to assist with this. It certainly can be used to obtain the training to get guardianship because, our firm does accept Family Support Services funding for the guardianship training that we do for families. So there are options out there to explore. Don't want full guardianship. There's limited guardianship where certain rights are left, and then there's the power of attorney. So those were the questions that were sent in. Do you want me to? I think I can pull up the Q&A myself.
I found them, but if you would like to read them, you're more than welcome to do so, if that would be easier.
Sure. So let me go from. Oh, this is a great question. So this viewer asked, what about future career of exceptional students who can't join college because of their impairment? That is a situation, I'm so glad someone asked that. There are certain secondary programs who will not take individual, I don't know if Clemson Life is one of them, who will not take individuals if guardianship is in place. Because theoretically, if anything happens in an emergency, they can't ask that individual, hey, do you want this treatment or not? They would have to call the guardian who may be in a different state or county. So that is something to think about if you want your child to go to one of these secondary programs, maybe exploring the program, seeing if guardianship will prohibit that or not. That's a great question. Next question, my daughter is 19. I contacted a lawyer to start the process. It's been 2 months. I was wondering how long it should take. The process generally takes about 3 months. Different counties work at different paces. Never hesitate to reach out to your attorney to say, hey, we just wanted to get a quick update, but just understand your attorney cannot move the court faster. It's not about them not being diligent. The court has its own process and we just have to be patient, but generally around 3 months. Okay, I don't speak Spanish, so I can't read that one.
We can probably have our Spanish interpreter read it for us.
Okay.
Mr. Rodriguez.
I got, what about if a person, and that's all I got.
Okay, we'll try to get Mr. Rodriguez on here
Okay.
to interpret the question for us.
All right. I'm gonna punt on this one. If the right to marriage is taken away under guardianship, how does the court view sterilization? That is a completely different topic. Just because you have a guardianship, you cannot go through a sterilization process. You would need a completely different court order for that. So that's really almost beyond the guardianship discussion. Now the next question, what if you have no one to look after your child? Will the state take over and help them become more independent? So if you don't have anybody, I urge you to find somebody. If you can't find somebody, like I said, there are state guardians, there are county guardians. Will they help your child become more independent? In my experience, the answer is no. They're just there in case of an emergency, and whoever is looking after your child, Medicaid, a group home, they're like, hey, this adult child needs some surgery. but there was guardianship in place with mom, but mom's passed. Who do we call to get permission? So almost, and I'm generalizing, of course, but those state or county guardians, in my experience, are more reactive than they are proactive looking out for the child. The next question, what have you seen as the benefit of the young adult wearing a med bracelet, the autism or other disability? I think those are great. You know, I understand it's a sensitive topic. Sometimes people don't want others to know their kid might have a diagnosis. I personally want more people to know so they'll keep an eye out for him or maybe understand certain behaviors. So I think that is great. You know, I'll have to ask the officers and prosecutors about that particular scenario. I've never asked that, but I'd be a huge fan of that. The next question is, what happens when there is an absentee parent? If the parent is absent and you apply for guardianship, or the other parent applies for guardianship, that absentee parent, if they have parental rights, so it's mom or dad, and they were married at the time, or the child has been legitimized, but not just on the birth certificate, but actually legitimized, so they have rights. That absentee parent has the right to notice that a guardianship proceeding is happening. Now, that parent can insert themselves in the process. They can object to guardianship. They can say they should be the guardian. But realistically, if you're in front of a judge and making that argument, and the applicant parent, I've been taking care of them for the last 10 years, I'm the one who feeds them and changes diapers and drives them around to all their appointments, and this parent sees them once a year. You know, the judge's job is going to make a decision what is in the best interest of the child. I can't say what that judge will do, but to me, that would be kind of a no-brainer. Next question, what if I feel my child needs a guardian, but discussing with him, he doesn't want it? He thinks he's okay like other kids, but parent knows he needs more support. That's a good question. So remember, if the child does not want guardianship, if you think they will themselves oppose your petition, you have a contested guardianship on your hands. And it is essentially a lawsuit against your child to remove their rights and take them for yourself. And remember, the court has appointed an attorney for your child. They will have counsel whose job it would be is to oppose your petition. So you would probably need counsel as well. So one thing I do suggest is introduce if it's something you're exploring with your child, introduce the concept to them gradually over time. You know, start at, 16 and a half, 17. What I found to have been effective is just saying, look, when you turn 18, you will be an adult. But listen, if you want me to make this appointment for you, if you want me to handle you signing you up for this, if you want me to get, this food or do this, I need authority to do those things. And so, that's kind of one of the things guardianship would give me. And so, the more gently you introduce them into the process, the better, making sure they understand it doesn't have to be permanent. It doesn't have to be permanent. I think that's important to make sure they understand. The next question, can one of the parents be the guardian when the child is over 18 instead of someone else? All right, I'm not sure I understand that one. So I'm going to pass that one. Can you still apply for guardianship if the child is over the age of 18 already? Absolutely. We have filed for guardianship for kids who are, the kid is in their 40s and the parents are in their 60s, 70s. So absolutely, it's never too late. Next question, if both parents live with the child or both granted guardianship, you can do it any way you want. You can say, well, we're just going to have one parent as the guardian just for ease of signing documents, or you can both be named, understanding that legally you both have to agree on all the decision making. You might have to sign documents together as co-guardians, but you can do it any way you want. Can there be multiple guardians in place if something happens to the parents? I don't, other than maybe parents being the guardians, I would not name a third co-guardian, because that becomes complicated. You can, especially if the parents are much older. I've seen it when one parent was in their 80s and the sibling of the special needs child was the other co-guardian. So I've seen it, but you want to be cautious when naming other people other than the parents as guardian. Can I provide some of the resources such as links or groups? So Parent to Parent is a great place to start. If you go to their website, there's a group. I don't know, at least am I allowed to put out names of groups?
Well, what you could do is just, if they contact Parent to Parent, then Parent to Parent can also, and I
Okay.
also can give out groups.
Okay.
for
So
parents.
email Lisa and she'll get you some stuff.
Yep.
What can be the best way to avoid getting the kid to be manipulated by contract signing, such as a credit card? And that is, it's the same thing we do with all of our kids, special needs or not. You annoy the tar out of them by saying, you shouldn't do this. You shouldn't do this. You shouldn't do this. And it's just educating them. I do find sometimes role playing for our special needs kids can be useful. You make it fun, you make it a joke. One parent or a sibling can be like, hey, that's a great Xbox, and I'll hang out with you if you sell me your Xbox for $20. And what would you do in that situation? But I find role playing is a way to make it fun. If you decide to do a power of attorney, does it have to be filed in court or notarized paperwork? Notarized paperwork is fine. It does not. Power of attorney does not have to be filed anywhere. Next question. They've gone to probate court to ask about this process. I was told they do not give guardianship to direct parent, but only to a non-parent. That is not right. Can you advise on specific office to go at the, well, I can't say which probate or what office to go to, but I will say that's completely not correct. The courts want the natural parents to want to be the guardians. They don't want to be like, hey, I'm done. Kid's 18. Give it to Uncle Joe over there. So either somebody misinformed you, or maybe there was a communications mishap. But I'll go back and talk to them again. How do you get an explanation of the OCGA, meaning the statute? You can try AI, or you can hire a lawyer. There are free legal services out there. You can go to other presentations. Almost all of them are going to address the guardianship process or statute. But what I say about that particular statute is it says what it says. That is it. That is the language directly from the statute. And so if you need more help on how it applies to your situation, that is where you either need to get a free legal resource or potentially hire an attorney to assist you. The next question, when you file, I guess, for guardianship, is their yearly checkup. You do have to file an annual report with your probate court, updating it on how the child is doing. It's not difficult. It's not overly complicated for guardianship. But yes, you do have to file something every year. If you don't, you're going to get that probate court's going to reach out to you and be like, hey, you owe us some paperwork. And if you don't get it in, they're going to tell you to come into court and tell them why you're not filing it. Do they still have rights if they join the Army? So, Mr. or Miss Mooney, that is a great question, and I do not know the answer to that. So I don't want to guess, but I'm going to find out. So I'll know for next time. I don't know if someone with under guardianship can join the Army. I have no idea. I would tend to doubt it, but I don't know. I don't know. You're always welcome to contact my office. Like I said, I'm glad to answer questions. If I can get on the phone while I'm driving somewhere and just chat with you for 10 minutes to help you think through the process, I'm glad to do that. We don't charge anything for any of that. So yes, feel free to reach out or email me and help you as best I can. The next question, my daughter is 17 years old, but her school is just starting her transition in January. Should be 18 in February. Is this normal for the school system to wait this long? So let me be clear. The transitional information from the school system is a blessing. It is not necessarily, I don't know, Ms. Lake, is that a requirement? I don't think that's a requirement to provide that information. So is it normal for the school system to wait? I mean, they're not required to do it. So, you know, I think we're lucky to be in a school system that offers that information at all. We have our next Spanish question, which I'll skip. Next question, if guardianship is taken in one state, is it valid in another state? So guardianship depends on where the ward resides. So if your child is here in Georgia, you get guardianship here in Georgia, then mom and dad retire to Florida, that guardianship in Georgia is still good. If mom and dad take the child with them to Florida, legally you do have to transfer the guardianship from Georgia to Florida. That is a bit of an involved process where Georgia has to initiate the transfer, Florida has to accept the transfer, and then do whatever Florida would want to do to ensure the guardianship is proper. If the adult child is under guardianship, can he or she marry? That is one of the rights that is taken away from that child. So no. What can be used as evidence for the need for guardianship? There's nothing in particular that you have to have, but we generally see things like the IEP. Psychological evaluations are good. Any medical record showing IQ, executive functioning, adaptive functioning scores. And then really, you know, any meds they might be on or prescribed. And really then your anecdotal stories of, look, this is why they can't make these decisions and why they need my assistance to be safe. Next to last question, what if you raised the child since he was 6 months old through the court, now they're 20? Could he make the decision to whom he wants as guardian? I think that's what that means. The court's always going to listen to that child. You know, if you want guardianship and you raise that child's like, no, I want my, let's say my natural parent to be the guardian, and that natural parent wants guardianship, that's, you know, that could be an issue that the court's going to have to decide. Last question, apologies, question been asked. What is the cost of doing guardianship? Can it be done through the school? It cannot, as far as I know, be done through the school. The cost of guardianship, you've got your filing fees with the probate court. You may have some fees to pay to the court-appointed attorney, though it's not regular attorney's fees. It's greatly reduced and controlled usually. So if you do it on your own out of DeKalb, you know, and you're paying for it yourself, you know, it could be anywhere from maybe $500 to $800 in that range. And then if you seek attorney assistance, like I said, some firms offer trainings, and of course you can always hire an attorney to assist you, though that does tend to get expensive. I'm glad to tell you what we charge. I don't know if that's appropriate or not, but
Well, they can contact you. They can
Okay.
contact you directly. We are at 7:30, which means it is time for our session to end. I really hope everyone had an opportunity to get your questions answered. I did, Attorney Jay, I did put your phone number for your office for, for families to contact you, and determine if they need to do anything further with you. I'll also be happy to share your information for any families that contact me as well, that want to learn more about what you're doing. I'll be happy to send that out. If you have not had an opportunity to do the survey, please complete the survey. It will help us to be able to make these sessions more meaningful. We do have another session next month on the now and comp waiver, Medicaid waivers. Katie Beckett waiver. We'll be talking about all of those things next month on December the 3rd. And I just wanted to tell Attorney Jerome, thank you for coming tonight. Truly, truly got a wealth of information. This was a wonderful session, and thank you for just being our speaker for tonight. And I will be definitely getting back in touch with you, in the coming days and sharing some more information with you. So, but thank you tonight, and thank you everyone for coming. We hope to see you next month.
Thanks for having me. Have a good night.